Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. And we have one case in the docket here at 11 a.m. It's Danny Myers, Christina Myers, and AM Miners versus Palm Bay Hospital, Inc., John McPherson, MD, and Brevard Physicians Associates. Joining me on the panel this morning are Judge Eric Eisnagel, and also for the first time this morning as a sitting district court judge, Judge Joseph Boatwright. We want to welcome Judge Boatwright to our court. And this is, I guess he's a veteran now. This is his second official OA right here. So when you are presenting your arguments, if you're not presenting your argument, please make sure that you silence any noise making devices so it doesn't interrupt the presentation by the other attorney. And also please just keep your microphone on mute when you're not speaking. I will assume 5 minutes for rebuttal. I see that we have 3 attorneys on the line here, but I'm assuming one attorney presenting for each party here. Or if that's not the case, please speak up.
Good morning, Your Honor. Dinah Stein on behalf of Dr. McPherson. We have 2 different defendants, and counsel and I have conferred and would, if it pleases the court, like to just split our time 10 minutes, 10 minutes. Okay,
then I will let you all monitor that time to make sure it's split equally, however you all want to handle that.
Yes, Your Honor.
And Mr. Harris will assume 5 minutes. Okay.
Yes.
All right. So with that, Mr. Harris, you may proceed.
Thank you very much. Good morning, Your Honors, and thank you for allowing us to appear by Zoom for the oral argument. I know it's not a right, it's a privilege. On behalf of all 4 plaintiffs, I will say Mr. Myers, I know it's in the record, he has passed away since the trial, but nonetheless, obviously, would be the substitution of the estate, particularly if this case is allowed to proceed to a new trial. Now, we do have 2 grounds for seeking a new trial. One is evidentiary and one is procedural. The evidentiary issue has to do with these guidelines, which is the industry standard, the Bible, for how you treat a patient who may be experiencing and then experiences a stroke, which at 4:21 p.m. unquestionably, Mr. Myers, hours after he had been admitted that day, did experience a series of stuttering strokes. Now, it is our contention that Dr. McPherson and the nurses at the hospital deviated from the standard of care by not consulting with a neurologist. They did not have a neurologist on staff, but they had the ability either by telehealth or by consultation with another hospital, Holmes Regional, to have consulted with a neurologist, and that the standard of care would have resulted in the administration of this powerful drug to break blood clots known as TPA, which I think most everyone here is familiar with outside of this case. Now, the thing with this drug, it has a 3 to 4.5 hour window, or it cannot be used. And so what is critical here for purposes of our theory as to where the trial court erred, the guidelines had shifted. The Bible, the AHA and ASA guidelines had shifted between 2015 and 2018. As of January of 2018, the new guidelines, the new industry standard went into effect. Danny was admitted to the hospital 4 months later in May of 2018, but the hospital had not updated its guidelines yet. And so the critical issue, there are 2 critical aspects. What changed in these guidelines? Why did the trial court err in not allowing these guidelines to be admitted into evidence? 2 different things. One, what changed? The concept of observation, last observed, versus neurological condition. When Danny was admitted to the hospital, he was by all question neurologically intact. The tests which were done all day, he was neurologically intact. Under the old guidelines, the prior observations, what Dr. McPherson said, I thought maybe he'd had a stroke in the prior 4 days, which would have ruled him out as a candidate for the TPA. Where the guidelines had shifted, it was no longer based on observation, but based on the neurological condition.
Mr. Harris, when you say the guidelines were not admitted, you're talking about the actual physical paper. I guess I'm dating myself, but not an electronic copy of the guideline, but the actual paper guideline. And you're talking about the guideline in its entirety. Is that correct?
Well, yes, we are referring to the paper document. It begins at R 1954 of the record, and it's a 54-page document. But to be clear, and the defendant makes an issue of this, well, not all pages of the guidelines were relevant to Danny's condition. The trial court could have very well avoided that issue by allowing the pages which were critical and relevant to Danny's treatment, and that's 1971, 1973, 1977 in particular. So yes, it was
that requested of the trial judge though?
the particular pages.
Yes.
So no, that specific request was not made, but the objection to the guidelines at trial was not that it was overbroad or that there were too many pages that were inapplicable. Had that been made, or had the trial court said, I'm not allowing these guidelines to be admitted because pages 1960 through 1965 deal with other stroke scenarios, it would have been a very simple fix to that, which is to allow the plaintiff to introduce the pages that were relevant. So that was not the reason for the exclusion.
Your first point was discussing the last known baseline neurological condition. Isn't that correct? Of the guidelines?
Yes,
And didn't trial counsel, weren't they able to discuss that with the witnesses, question the witnesses, even show them pages out of the guideline?
Well, yes, and that goes to the question of what I would contend, the harmless error test. The failure to admit the guidelines themselves were unquestionably, in our perspective, erroneous. The defendants offered all sorts of explanations. Hearsay, it was not. Improper bolstering, it was not. Learned treatise, it was not.
Why is that not cumulative?
What's that?
Why is that not cumulative?
Okay, well,
bring it out during the testimony and even show the witnesses the pages.
Well, for one, the trial court did not exclude the evidence on the basis of cumulativeness, nor did the defendants argue that issue. But so I would contend that this court could not be in position here to affirm the ruling on what could have been a discretionary call that the trial court never exercised. But getting to the heart of your question as to why it's not cumulative, because the documentary effect of the papers is much different than the jurors hearing it itself. A case from the 4th District we cited, Wax versus Tennant, is the form, substance, and function the same? No, it's not. Gutierrez versus Vargas talks about relevant confirmatory testimony. For the jurors to have gotten their hands on the document itself, which was, I don't like to use the term, no religious term, but it is the Bible. There were no competing guidelines. There is no serious argument the defendants make in their brief that these were not the accepted guidelines as of January of 2018. And so, yes, you're correct. And the defendants, you'll hear the defendants argue harmless error, or the defendant who addressed harmless error in their answer brief, Dr. McPherson, harmless error under the special test.
Well, I know you say this is the Bible. I don't know if that's a legal standard. What's the legal argument for you being able to admit these guidelines into evidence?
Yes, Your Honor. Two separate and independent reasons. One, it's the industry standard of care.
Was there any testimony that these were industry standards of care brought out?
I believe our expert, Dr. Farrar, testified that this is the standard of care in the industry. And there is no, in fact, the defense expert, Dr. Aiken, admitted he would have used the guidelines themselves, the 2018 guidelines, had he been. So there was no evidence to the contrary. It was and in fact, the hospital later adopted these guidelines. There were no other guidelines to use other than the AHA, ASA guidelines. So there is no question that
Can you point us to the page in the transcript where there was testimony that the 2018 guidelines were the industry standard?
I will get that for you for my rebuttal.
Yeah, maybe on the rebuttal you can find it while your opposing counsel is. You don't need to point it out to us right now.
Okay, I do have it. T32, 31, 33, 41, 42 is when both of the defense experts testified that they use those very guidelines. And Dr. McPherson also testified that he utilizes.
But using the guidelines is close, right? But is that the same thing?
It is. Well, it's not the same thing, but the fact that the hospital utilizes the guidelines, that fits into a second reason to admit the guidelines.
The hospital didn't utilize the 2018 guidelines. They utilized the 13 and 15 guidelines, correct?
That is correct, certainly as of May of 2018, but as an adoptive admission under 90.80318, separate from it being the industry standard of care, there is no question that the hospital manifested a belief in the truth. Now, you're right, they did manifest a
adopted
belief.
Didn't they adopt these after the fact, though? Not while the incident happened, correct? It was after the fact adopted.
That
They're
is
still operating under the 13 and 15 guidelines, correct?
Yes, you are correct, Your Honor. But they do not argue that the adoptive admission is inapplicable because you later adopt it. And I haven't seen any case law that exception, which again, I don't think we even need to get there because of the industry standard of care. But even assuming it was not the industry standard of care, it was adopted by the hospital. There is no question. Their nurse Metner testified she went to a conference in January of 2018, 4 months before, and was implementing these very guidelines. They are in a binder now for their hospital staff. Now, the defendants say in their brief, they don't say a lack of adoptive admission because it wasn't there as of May 4th, 2018. What they say is, in part, well, we don't know when the hospital adopted them. It doesn't matter whether it's 2019 or 2020. That part, well, I guess after trial would have mattered, but it was certainly adopted as of the time of trial in 2021. The fact the exception does not require to have been, and as I said, I don't see any case law requiring the admission to have been contemporaneous at the time of the treatment that Danny was admitted into the hospital. So it was unquestionably.
So it's almost like a retroactive nunc-pro-tunc adoption of the guidelines, 2018 guidelines.
Well, yes, if you put it like that, why is this a hearsay exception? And again, I don't think we need to get to the hearsay issue, but why is it a hearsay exception? Because if a party later manifests a belief in its truth, there's no reason to not allow it to be admitted into evidence. And I would just contrast this case to the Philip Morris versus Polari case we cited from the 4th District, where an Engel case, the tobacco defendants had a link on their website to Surgeon General reports, but they expressly disclaimed that the reader should rely on the accuracy of that information. They were providing it merely for convenience. And so the 4th District held in that case that the adoptive admission could not be applicable there because the tobacco defendants had never manifested a belief in its truth. Everybody here, Dr. McPherson, Nurse Metner, the hospital, the defense experts, there are no other standards here. Let's take out the phrase the Bible and understand that this is the industry standard. These are a patient who is admitted today with the second issue, as to the observed versus neurological condition. And the other issue, which is why this was so relevant, is because Danny had a prior stroke. Danny had a history of diabetes. Under the 2018 guidelines, these were no longer relative exclusions for the use of TPA.
Counsel, as far as a harmless error type analysis, you agree that we should conduct a harmless error analysis?
Certainly,
Can you give us any substantive sort of reason why the testimony was insufficient substantively? I understand what you're saying, that, hey, look, having the document in front of the jury matters. I get it. I understand what you're saying there, but is there a substantive problem here with the testimony was insufficient and we needed the document here substantively? Here's why.
Well, no, substantively, certainly there was expert testimony on what the 2018 guidelines said and why they were different. I will say that this came up in Dr. Aiken's testimony. We were precluded, which is where the trial court precluded the guidelines from being used. Defense counsel was able to ask the witness questions referring to other pages, earlier pages in the guidelines. And so we were harmed by the inability to show the guideline pages to Dr. Aiken and present those to the jury. So that would be an example where substantively, I would argue we were harmed. The other thing.
And Mr. Harris, substantively, I believe the facts came out that if the 2015 guideline was operative, then they did not fall below the standard of care. But if the 2018 guideline is what they're having to comply with, they did fall below the standard of care. Is that correct?
Yeah, I mean, certainly the defense argument, yes, under the 2015 guidelines, because Danny did have a history of a stroke 6 years earlier. He did have a history of diabetes. And there were at least these reports that he had not been feeling well in the days before he was admitted to the hospital. Now, our position was Danny thought it was related to him being on a cruise. Dr. McPherson characterized it as stroke-like symptoms. But yes, under the 2015 guidelines, the defendant was certainly in a much stronger position to argue we did not deviate from the standard of care because Danny was not the right candidate for the TPA. If I could just briefly go back to the harmless error issue, the question I know it's posed, and it's a fair question to me to ask me what is substantively different, but the harmless error test doesn't put the burden on me to establish anything, of course. The harmless error doctrine puts the burden on the defendants to show that there is no reasonable possibility that the error affected the verdict. That's in an evidentiary, and there was a strong dissent in special, and there's been discussion since then. It is an almost impossible test for an appellee to meet in a jury trial. I'm not saying it's impossible. There are times that it can be met, but it is their burden to prove there's no reasonable possibility. Why did the defendants, what I would ask, or my commentary, why did the defendants fight so hard to exclude these guidelines? Their arguments had no basis in law. The hearsay argument, the bolstering, the learned treatise, every which way they went, they did not get to cumulativeness, as I said. But why did they fight so hard to prevent the plaintiff from having their experts show this, go through this, to prevent plaintiff from showing to the jury in closing argument? That is a very powerful difference than plaintiff's counsel telling the jury in closing about what the evidence showed. To actually give that to the jurors were out for 4 hours. This was not a 10-minute defense verdict. This was fiercely contested. Now, I don't suggest that the evidence was overwhelming for a plaintiff's verdict and that the jury, this is not one of those scenarios, but that is not, it was a fiercely contested case, which could have easily gone either way. And the defense, I
understand your argument there. It certainly raises eyebrows when at least a little bit, when the appellee below strenuously opposes some evidence and then on appeal says, but it was harmless. And that's the argument you're making right now. I understand that. Do you want to, just before you go into your rebuttal, perhaps we'll have a little bit extra time for both sides on this case, but do you want to just briefly discuss your second argument?
Sure. Thank you very much, Your Honor. Now, the second argument has to do with what was a colossal discovery. Now, it may not have been intentional bad faith misconduct by the defendants, but it was certainly wrongful, improper conduct. We made very clear discovery request after discovery.
Yeah, no, I mean, counsel, we're familiar with the procedural background and what happened. I guess my big question there is, did you do enough? It certainly seemed pretty bad to, that's a technical term, right? But, I guess the question is did you do enough to preserve the error or not waive it, if you will? It certainly seemed like your opposing counsel, well, not seemed, they moved for mistrial, and it certainly seemed like your side opposed that motion. Certainly you didn't join it. You knew about the problem during the trial, and you didn't ask for a mistrial until afterwards, and there's there's that one case saying you can't have your cake and eat it too. Can you address that?
Yes, and we addressed that in the initial brief, and I understand. What I will first say is what we requested was overruled by the trial court. What we requested was that the trial proceed as it had preceded a discovery from the defendants for many years, which is that what they turned over to us during this video inspection was the actual stroke test order for Danny McPherson.
I think wasn't the bigger issue that it was actually a document from a different hospital. Wouldn't you agree that's a bigger problem even?
Well, I think they were both pretty big, but certainly that came out later in the trial. That was the second surprise, if not shock, is that what they claim, and I'm still not sure to this day what the actual.
At that point, I guess my point is, at that point, didn't you need to say, Judge, this is too much? We have to have a mistrial at this point.
I understand that, and we certainly do raise the issue of fundamental error, and I do believe this rises to the level of fundamental error. I understand the concept, but if you put yourself into the position of a litigant, this is a plaintiff or a defendant, a multiple week trial, you have prepared your case based on what has been turned over to you in discovery. It may not be intentional bad faith, but it was wrongful conduct. The defendants had their own employee who prepared a test report in the middle of an inspection without informing the plaintiff's counsel. how is that not unconscionable? However good-hearted that lady may have been, how is that not unconscionable in the context of a 3-week trial to force a party to make a decision to join and have that entire trial start all the way over because of that discovery misconduct? It does rise to the level of fundamental error to the extent that this court feels that we didn't preserve it by not having what we requested overruled, disagreed with by the court. We did not oppose the mistrial. I certainly acknowledge that we did not join in the mistrial.
I mean, counsel,
But
reading the transcript, I had the impression that you were opposing it.
what we opposed, what we opposed was the trial what we mostly opposed was the trial going forward with this being presented as an exemplar and the plaintiff being blamed in the sense of all I will say was that I understand what you're saying. We did not tell the court you cannot grant a mistrial here. You don't have that's what when I say we did not, that's what I mean by we did not take a strong position on that issue. But again, to force a party weeks into the trial, almost through their case in chief, to give up that entire trial for, as we saw, the decedent died just a few months later. Danny died a few months later because of their blaming. It was their discovery misconduct. This is not an evidentiary issue that comes up spur of the moment issue. You decline to join a mistrial. You don't move for mistrial. You're trying to have your cake and eat it later. This was our entire case, which was premised on what was a falsity regarding this being a so-called test report. And then, as you mentioned, the issue that it was not even a stroke set, that Dr. McPherson ordered a stroke set from another hospital, which doesn't have a telehealth program, which doesn't have a consultation requirement because they have their own neurologist on staff.
Mr. Harris,
so
you're past your time has expired. I'm gonna stop you there and we'll see how much rebuttal time to give you once the appellee is finished with their presentation, okay?
Judge Wallace,
Thank you very much.
For purposes of trying to be balanced for both sides, I would, if the panel's okay with it, I would recommend that we just give both sides 2 extra minutes. If the panel is okay with that.
Okay. We'll let the appellee go ahead and start and see how we end up.
Thank you, Your Honors, and may it please the court, Dinah Stein on behalf of Dr. McPherson. And just to address the guidelines, this was a classic discretionary call by the trial court who reviewed the 54-page document and determined in open court correctly that the vast majority of the document was completely irrelevant to the issues in the case. He said this on the record, and it is shown by the guidelines. These guidelines dealt with things like pre-stroke, pre-hospitalization management, emergency medical services like EMS, that hospitalization management, rehabilitation. These issues had absolutely nothing to do with this case, which dealt with the emergency room presentation and decisions on whether or not to give TPA. So the court made a relevance determination, which was absolutely correct. But perhaps more fundamentally, this plaintiff still has not articulated what information the jury was allegedly deprived of due to this ruling. And in fact, no fewer than 4 medical witnesses testified as to the guidelines. They discussed the differences between the 2015 and 2018 guidelines. There was no dispute as to what the guidelines said. And in fact, as was pointed out, Dr. Aiken was shown the critical page of the guidelines on the projector and cross-examined in that regard. So this, the guidelines issue falls, I'd say, directly under the Sims versus Brown case, which it involved a joint commission manual that was excluded because in that case, just like this case, plaintiff took an all or nothing approach. They wanted the whole document in. They did not ask the court to just admit the pages that were relevant. And the court said, I'm not allowing the document in. And in Sims versus Brown, the Supreme Court said that where it comes in anyway, through 2 witnesses, then it's completely harmless and not grounds for a new trial. So the jury heard this evidence. Plaintiff's counsel discussed it extensively in closing. It was undisputed. There is simply no error here.
Are these guidelines industry standards? Are they the industry standards?
Well, there was no testimony that they were. And in fact, Mr. McPherson's trial counsel, Mr. O'Hara, said to the court, we do not, there's no consensus that these are industry standards. So there's nothing on the record that would allow a court to come to that determination now. Now, as far as the standards, or let's say the guidelines that were relevant to this case and shown to the jury or discussed, it's irrelevant because the jury heard it. And as far as the non-relevant guidelines, there's absolutely nothing in the record to show that they're industry standards. Not one witness testified as to what type of stroke management you have, pre-hospitalization. So no, most of them were not just established as industry standards. The relevant ones came into evidence, so I would submit it doesn't matter, and the rest were just hearsay. And just one other point, the hospital's policies and procedures, they cite to several references that they used in creating these policies and procedures. One of them happened to include the guidelines. There were 3 other sources. There was certainly not an adoptive admission of anything. And as Dr. McPherson did say in his brief, if anything, the 2018 guidelines weren't adopted. Even if you could say that the link or the hyperlink was somehow an admission, it wasn't of the 2018 guidelines. So, it was a reference that the hospital obviously compiled a number of sources in putting together their policies and procedures, which was in addition to the guidelines. So, if anything, that indicates that perhaps the guidelines are helpful, but not necessarily the industry standard when there are other sources to go by as well.
So Ms. Stein, would you say that even the 2015 guidelines, which I believe the evidence was the hospital was abiding by those, were not properly admitted or shouldn't have been properly admitted as adoptive admissions in this case?
Under the Polari case, well, first of all, I'm not sure, that the plaintiffs are asserting that on appeal. They wanted the 2018 guidelines.
I understand, but the facts of the case were the hospital was, at least they were aware of the 2015 guidelines, correct?
Correct. And to answer the question, absolutely not. The Polari case speaks to this. To be an adoptive admission, it has to be an express adaptation of what the source is saying. I mean, in that case, that was even probably a stronger connection where a tobacco company on its very website referenced its readers to documents and from the Surgeon General. And the 4th District said, even that's not enough. It has to be an express adaptation. So here, it's not a hyperlink sending the doctors to this document and saying, or the medical providers and saying, here, you need to read this. It was a reference. It was 1 out of 4 references. So it's absolutely not an adoptive admission, even of the 2015 guidelines. But in any event, the 2015 guidelines are not at issue. They're not in the record. They were discussed and compared, but the plaintiffs, in essence, got to discuss with the jury everything they wanted to discuss in regard to the guidelines, and the guidelines were undisputed as just being guidelines. So on that, clearly harmless and clearly not error, as most of it was irrelevant to the issues in the case and confusing to the jury. Now, on the issue of the stroke alert document, I just want to make clear with the court what the plaintiff is asserting on appeal. And that is the discovery issue. And I think that's important because all of the discussion they have in their brief and the motions for mistrial by the defendants and the arguments going back and forth had to do with an evidentiary aspect of that, which is when plaintiff's counsel tried to make a test exemplar look like a real document. It was the defendants who said, from an evidentiary perspective, that's prejudicial. The plaintiff wanted to just continue questioning Nurse Watson as if it was part of Mr. Myers' medical chart. The court heard everything. He frankly cut through everything and said, we're talking about one document regarding one witness who's still on the stand. We can easily fix this, which he did. He gave a curative and moved on. That's not what plaintiffs raise on appeal. They say just the very fact that they were given this exemplar and they believed it was part of Mr. Myers' chart. And then this new information regarding what stroke panel Dr. McPherson used was prejudicial. Well, to make it clear, this was very well known to plaintiff's counsel during their case in chief. And the court heard hours of argument. He heard testimony. He made an express finding that nothing improper was done by any side. He said this is just the nature of electronic medical records and people who don't understand, legal discovery requests. Nothing was intentional. But plaintiff's counsel not only didn't move for a mistrial, she made clear that she had a sufficient predicate to move forward with her theories of the case, even after learning that Dr. McPherson used a different hospital stroke panel. She said, you know what, I've still got my predicate because the hospital's the health unit coordinator, Tori Hare.
Counsel, is this when you take the two sort of we'll just call them revelations, perhaps you wouldn't call them revelations. It sounded like from my reading of the record, at least the second one we could call a surprise, to say the least, to both sides. I think counsel below even admitted that it was shocking to find that out mid-trial. Is it your position that this is, hey, no big deal at all? Or, because it seems to me like it is a big deal. And if it's not, please disabuse me of that perception. Is it your position that, gee, it's not a big deal, and even if they had moved for mistrial upon discovery of this problem, that it would not have been properly granted? Or is it simply your position that, yes, this might have been a big deal had they moved for mistrial, perhaps it should have been granted, but they didn't? Which one of those is your position?
Well, the position, first of all, to say it's not a big deal, it's I'm not trying to, I guess, minimize revelations during trial, but we have to go by the record that was there. The record that was what we have in front of us is that everyone was surprised when they learned that Dr. McPherson didn't use the hospital stroke panel. The rest of this depends on how this impacts the case.
You actually used at different hospitals.
Right. He used a different
right?
hospital.
An entirely different hospital.
Right. And so the next inquiry then is, let's say there had been a motion for mistrial. Well, how does that bear on the issues? And that's critical, because it's one thing if this bears on the issues, if it's
let me ask you that. I mean, fair enough, but you're more familiar with the case than I am. But let's think about it this way: what sort of theory? What about adherence to the standard of care? When you're using an order from an entirely different hospital that you're not supposed to be using, it seems like perhaps that creates potentially some significant arguments on standard of care. Do you disagree?
Well, I disagree. And I think, the proof is in the record, because Dr. McPherson was at trial. Obviously, he was a defendant, and plaintiff's counsel could have dealt with this had they wanted to. They could have asked him in for questioning. The court allowed this as to the hospital representative. They could have questioned him. But
hold on, they could have questioned him right in front of the jury mid-trial?
No, they could have brought him in, as they did with the other hospital representative, to the court and done additional discovery. Recall there was a deposition taken during the case too. The plaintiff's counsel, who was incredibly familiar with this case, I mean, there's no doubt, they really worked up this case in discovery, was not as moved enough learning of this new fact to say, you know what, I can't go forward. In fact, she specifically said, I can go forward.
Right, but my question was, if she had said, this prejudice, this is of great prejudice to my case, we move for a mistrial. My question was, should that motion been granted, or was it still nevertheless no big deal?
It was still nevertheless, I don't want to say no big deal, but it was no big deal if that's, the court's wording of it. It was not grounds for a mistrial because of what the theories were of the negligence. For instance, the question was, did Dr. McPherson make a correct determination in not consulting with a neurologist? And whether he used, which hospital's panel he used, has absolutely nothing to do with that. He testified.
Really? I mean, the other hospitals did the other hospitals order have the same sort of options when it comes to consulting a neurologist? I honestly don't remember that. I think that there were some differences.
There were some differences which were cured by the words of plaintiff's counsel, by the testimony of Tori Hare, the hospital health unit coordinator, because she testified to the jury that the stroke panel he actually used, the other hospital stroke panel, would have triggered a telestroke conference. So the predicate was there. It did not change plaintiff's case one iota. And if it had, there is no doubt plaintiffs would have moved for a mistrial. They were very comfortable in moving forward. They said on the record, we still have enough to prove our case. And the only theories, I mean, I think it's critical just to look at what the theories of the hospital were. They were, you know, whether he properly consulted a neurologist and whether whether the hospital, you know, should have triggered a stroke alert. Now, I want to go on, but before I do, I just want to see, I'm looking at the clock and I do want to give time to my colleague. Do I have 6 minutes left or do we have 6 minutes left, Your Honors?
I'm gonna take Judge Eisnagel's suggestion and add 2 minutes. So you have a little less than 8.5 minutes total for the appellee. So use that time wisely.
Okay, in that case, I don't want to deprive the hospital counsel of using the remaining time. If understanding that we have a total of 6 minutes left.
Total of 8
Okay.
minutes.
8 minutes. I'm going to allow Mr. Boland, unless Judge Eisnagel, if I was in the middle of answering
No,
your
that-
questions.
You answer them. Thank you.
Okay, thank you, Your Honor. Then I'll give the rest of the time to Mr. Boland.
Okay.
Thank you, Ms. Stein, and may it please the court. I'll do my best not to be repetitive of the issues that have already been well argued by both sides. I want to touch on the guidelines for just a moment because I want to make sure that it is clear that the guidelines that we are discussing are just that, meaning guidelines that can aid or assist a practitioner in providing care and treatment to the patient. Nowhere in the guidelines does it suggest, however, that that is the standard of care from the standpoint that a physician or a clinician must always use each and everything that comes from the guidelines in their treatment decisions. In fact, what the experts and what Dr. McPherson testified to is that although they utilize the guidelines, what they always have to express some level of clinical judgment. And that's what this case was actually about, was whether or not Dr. McPherson properly recognized or understood that the symptoms that Danny Myers was exhibiting were in fact new stroke symptoms versus a continuation of signs and symptoms that had taken place many, many days prior. And that's really what the focus, if you look at the record in terms of the most hotly contested issue throughout the trial was, it really was about whether or not Danny Myers showed up to the hospital already with stroke-like symptoms, even though his baseline had returned, or whether or not Danny Myers never had stroke-like symptoms before he hit the hospital door, and that later in his care and treatment that Dr. McPherson should have recognized and initiated a stroke protocol. So the guidelines, unlike the Polari decision, where we're talking about facts and findings from a scientific standpoint, we're talking about the difference being that physicians and clinicians have to exercise clinical judgment in the application of those guidelines. And if we're going to admit a guideline in a documentary or evidentiary form, it has the potential to mislead and confuse the jury from the standpoint, number one, that that wasn't the guidelines that the hospital testified they were following at the time. But perhaps more importantly, then it raises the standard of that document and the jury can be misled to believe that the document is in fact some type of binding authority or policy that a doctor must follow. And in fact, that's not at all what any of the clinicians testified to. All of them, however, did talk about the key issue in the case, which was the window for TPA and whether or not TPA should have been used in Danny Myers' case with respect to the concomitant medical conditions that Mr. Myers also exhibited. I also want to touch briefly on the stroke alert protocol and answer the question about whether or not it was so central to the plaintiff's case and the underlying case during the trial. If you look at the record, That stroke alert order set that we are arguing over was never mentioned during the opening statement of the plaintiff. It was never utilized during Dr. McPherson's cross-examination. It was only brought up for the first time in the case when Ms. Hare was being questioned and Mr. Watson was being questioned. That was the first time that it was ever mentioned. Throughout the entire case, the entire working premise of the case was that Dr. McPherson should have initiated those orders, should have initiated a neurological consult, and should have begun the administration of TPA. And he denied that he had ever done that throughout the entire case. So for the plaintiff to suggest later that this stroke alert, this stroke panel was in fact ordered would be entirely contrary to everything we learned throughout discovery and all of the relevant evidence that was placed before the jury, including the very arguments that were being made by both plaintiff's counsel as well as defense counsel throughout the course of the trial. And as everyone has already correctly pointed out, of course, that the concern from the defense was great, that we had now entered this document suggesting it was part of Danny Meyer's chart, when in fact it was not. And we felt that was potentially prejudicial. Judge Holcomb, in weighing all of that, decided that the trial could move forward, and the plaintiff agreed. I want to be clear. I was trial counsel for Palm Bay Hospital. I'll be clear that it was not simply a acquiescence to the fact that the mistrial was denied. There was active and vigorous opposition to a mistrial being declared during the trial, and that's evident from the record and the arguments that were being made. And so for those reasons, I believe that the jury verdict should be upheld.
Thank you, counsel. Mr. Harris, you have about 2 minutes.
Thank you very much. I'm just going to quickly just give some cites. I know I was asked regarding the industry standard of care. I do believe, first of all, it was never questioned at trial with any evidence, but T1227, T1230, 31, our expert discussed the industry standard of care. T1390 is where Dr. McPherson acknowledges that these are the guidelines, the AHA, ASA guidelines, and then the sites I gave before during Dr. Aiken's testimony, which is 3231 and 3233. There's no question in my mind that at trial that this was the industry standard of care, and there was no opposition to that, and for that reason alone, it should have been admitted. Now, Ms. Stein said this was a discretionary call by the trial judge. The trial court committed an error of law in failing to follow the rules of evidence, to the extent whether you didn't really hear them discuss whether this was improper bolstering, it was not, or whether it was a learned treatise, it was not. Ms. Stein also talked about the Sims versus Brown case. In that case, the trial court expressly excluded the evidence as being cumulative and not relevant. That did not happen here in this case. Ms. Stein said, well, they asked for an all or nothing. Again, if they had raised the objection that our request for all the guidelines was over-inclusive, there would have been, and the trial court had signaled that is why it was excluding that evidence, there would have been a very simple fix. That was not their objection at trial. That was not the trial court's ruling. I think I respectfully submit it would be error for this court to affirm the trial court on account of it being cumulative. It was not cumulative. As I said before, the documentary evidence, the defendants don't present, and they're correct that the expert testimony came in, but not the actual documentary evidence. And that would have been a critical tool for us to use in front of all the witnesses and then during closing. The issue of unpreserved error here, I will just gently remind the court, I know the court knows this, but if this court concludes that the second point is unpreserved and it doesn't rise to the level of fundamental error, this court can also, the concept of cumulative error, can consider preserved errors and unpreserved errors together. And so I would just present that as another alternative for the court if the court is going to go there and doesn't think that point 2 is preserved or on its own is fundamental error. I would ask the court to consider that under the doctrine of cumulative error. This was not a fair trial. Whether there was intentional bad faith is not dispositive. It was wrong. It was harmful. It was not going to be curable during this trial. and the fairness and integrity of the trial process is in serious question when you have a trial brought under a false premise because of the discovery that one party turns over to the other after repeated time and time requests, including the video inspection, which I know this court now has in front of it today. I think I'm probably over my time.
You are.
Okay, thank you for indulging me, and I would obviously ask this court to reverse and remand for a new trial. Thank you very much.
All right. Thank you, counsel. It was a well-argued case. We are adjourned. Have a nice day.